The moment a cop walks up to your window and says, "Do you know why I pulled you over?" Most drivers fall straight into a trap. And here is what happens next. You answer. Maybe you say, "I think I was going a little fast." Maybe you say, "I wasn't sure about that light." Either way, within 10 seconds of opening your mouth, you have just handed the officer the one thing they needed most, your own words used against you. Most people respond because silence feels guilty. It feels aggressive. It feels like you are hiding something. But that instinct to explain yourself, that is the trap. Through tactical analysis of over 200 recorded traffic encounters, I have identified the exact pattern that separates drivers who walk away clean from drivers who talk themselves into citations, searches, and worse. 5 legal moves flip this dynamic entirely. These are not tricks. These are documented, field-tested counter moves that control the encounter from the first second to the last. Move number 1 rewires how the conversation starts. Move number 2 turns the officer's own equipment into your evidence. Move number 3 shuts down questioning cold, but only if you say it the right way. Move number 4 is the card most drivers forget they hold. And move number 5 starts a clock that works entirely in your favor. Stay locked in. Because the most dangerous move on this list is not number 5, it is number 3, and most people get it completely wrong. I am going to break all 5 down right now. This is tactical education only. For specific legal guidance, consult a licensed attorney in your jurisdiction. Legal move. Number 1, make the officer talk first. Here is the real situation. The officer walks to your window. Your hands are at 10 and 2. Engine is off. Keys are visible on the dash. Dome light is on. Window is cracked 2 to 3 inches. Enough to pass documents. Not enough for anyone to reach inside. The officer leans in and says the most common opening line in traffic stop history. "Do you know why I pulled you over tonight?" This is not small talk. This is a trained interview technique. Officers are taught in the academy that the single most productive question they can ask is one that makes you explain yourself before they have committed to any narrative. The wrong move sounds like this. Officer, "Do you know why I pulled you over tonight?" Driver, I might have been going a little over the limit back there." Officer, "How fast do you think you were going?" Driver, "Maybe 60, 65. You just confessed to speeding before the officer said a single word about evidence. Your countermove is clean, calm, and completely legal. You say, "No, officer, I don't. Why did you stop me?" Deliver it with steady eye contact, neutral tone, no defensiveness. Say it exactly like that. "No, officer, I don't. Why did you stop me?" That single line does 3 things simultaneously. First, it forces the officer to state the legal reason for the stop out loud, on their body camera and on yours. Second, it removes any pressure on you to perform or fill the silence. Third, it flips the dynamic entirely. You are now listening, not confessing. Once the officer states their reason, your response is measured and minimal. "I understand. Thank you." That is it, if they get vague. "You seemed to be swerving." Your follow-up is equally precise. "Which lane and approximately what time, officer?" You are not arguing. You are documenting. Under Terry versus Ohio, officers must have articulable specific facts to justify a stop. When you make them say those facts out loud on camera, you have just created the foundation for every legal challenge that follows. Here is what the escalation path looks like when you skip this move. Officer asks why you were stopped. You say, "I think I was going a little fast." Officer says, "How fast?" You say, "Maybe 60." Officer says, "The limit is 45. Step out of the vehicle." You just walked yourself from a potential warning into a situation where the officer now has your verbal admission, a justification to escalate, and your cooperation on tape, none of it working in your favor. Contrast that with the counter move in play. Officer asks why you were stopped. You say, "No, officer, I don't." "Why did you stop me?" Officer states the reason. You say, "I understand. Thank you." Your record is clean, your words are minimal, and the camera captured exactly what you need. Tactical summary. Never guess the reason. Make them state it, lock it on record. Officers know that some drivers will stay quiet after deploying move number 1, so they have a backup play they run almost immediately, and it involves the one thing most people assume is working against them. Move number 2 is how you take that asset and flip it into your most powerful tactical weapon on the roadside. Legal move number 2, use both cameras as your weapon. Most drivers see a body camera on an officer's chest and assume it only protects the cop. That is one of the most costly misunderstandings in any traffic encounter, because detailed examination of over 150 body cam recordings proves something different. When drivers know how to perform for that camera, the footage becomes their evidence. Here is how this plays out in the field. Officer walks up. You have already deployed move number 1. They state the reason for the stop. Now, before anything else happens, you say clearly and calmly, "For everyone's safety, I am recording this interaction as well." That is the line. Deliver it without attitude, without edge. "For everyone's safety, I am recording this interaction as well." If the officer asks why, your follow-up is, "Just for transparency and accuracy, officer." Nothing confrontational. You are simply establishing that this encounter has 2 records, not 1. Cameras document everything, and now both cameras are capturing the same truth. Watch how the live exchange looks when you get this right. Officer: license and registration, please. You: absolutely. My license is in my wallet in my back left pocket. May I reach for it? Officer: go ahead. You: my registration is in the glove box. I will reach slowly. Every movement announced. Every action narrated. On camera, you have just demonstrated calm, deliberate cooperation, the polar opposite of someone hiding something. On that same camera, the officer must now be precise. Training manuals across major departments specifically instruct officers that body cam footage will be reviewed by supervisors. When drivers introduce a second recording device, the standard of conduct elevates immediately. What you cannot do: hide the phone, make sudden movements, or say anything confrontational. What you must do: hold the phone in plain sight or keep it dash-mounted and narrate your actions throughout. If the officer asks you to stop recording, your response is, "Officer, I have the right to record this interaction in a public space." Say it once calmly and continue. In virtually every state, recording a police officer during a public encounter is protected activity. Do not hide the phone. Do not argue about it. Just continue narrating. Your recording plus their body cam equals your tactical advantage. That combination creates a dual record extraordinarily difficult to contradict later. If anything escalates, raised voices, a pressure move, a consent claim you never gave, the footage tells the truth. Tactical summary: announce your recording early, stay narrating, and let both cameras work together as your field evidence. Now you have the reason on record and 2 cameras capturing everything. But here is what body cam footage consistently reveals happens next. The officer shifts from stating facts to asking questions. And the moment they ask, "Where are you coming from tonight?" or "Have you had anything to drink?" you are no longer in a traffic stop. You are in an interrogation. Move number 3 is your counter to that shift, and it is the move most people get wrong in a way that actually destroys the protection it is supposed to give them. Legal move number 3, invoke silence the right way. Here is the trap inside the protection. You have the right to remain silent. Every driver knows this. But tactical analysis of hundreds of field encounters reveals a Fifth Amendment loophole that officers are specifically trained to exploit. The Supreme Court, in Berghaus v. Tompkins and Salinas v. Texas, ruled something that sounds completely backward. Your right to remain silent does not protect you if you simply go quiet. If you start talking and then stop talking, officers can argue that your silence is an implicit admission. The wrong move is also the most common one. Officer: where are you coming from tonight? Driver says nothing, just stares ahead. That silence, according to those Supreme Court decisions, can be used against you in court as implied guilt. Your counter-move requires one specific sentence, stated clearly, and only once. Officer: I am invoking my right to remain silent. Deliver it calm and flat. No attitude, no volume, no elaboration. Officer: I am invoking my right to remain silent. Then stop talking. Completely. That sentence does something legally decisive. It creates an unambiguous on-camera record that your silence is a constitutional exercise, not a behavioral tell. Say it again so it locks in. Officer: I am invoking my right to remain silent. Here is the live exchange that follows for most stops. Officer: have you had anything to drink tonight? You: Officer, I am invoking my right to remain silent. Officer, come on, I just want to make sure you are okay to drive. You. Silence. The officer just tried the cooperation pitch. A trained technique designed to make you feel like staying quiet is unreasonable. It is not unreasonable. It is your constitutional right, properly invoked. If they push further and say, you don't have a right to an attorney right now, do not argue. Do not react. That statement by the officer is legally false, and on camera it looks exactly like what it is. What you are not required to answer, where you are coming from, where you are going, whether you have been drinking, what is in your car, what you are required to provide, in most states, your license, registration, and proof of insurance. Provide those. For everything else, the invocation stands. Stay calm, stay tactical, stay in control. Tactical summary. Silence alone is not enough. You must say the words. Invoke it once, clearly, then go completely quiet. That countermove shuts down the question track. But here is what tactical research across dozens of escalating stops shows. When drivers invoke silence, officers frequently pivot to a new pressure move. They start probing for consent to search. And that pivot leads directly to the most powerful card in your hand, one that most drivers do not realize they can play before anything has gone wrong. Legal move number 4, play the attorney card before it gets bad. Here is the truth most drivers do not know. You do not need to be in handcuffs to ask for a lawyer. You do not need to be under arrest. The moment an officer starts asking questions that go beyond the traffic violation itself. Where were you coming from? Have you been drinking? Do you mind if I look around the car? You are no longer in a routine stop. You are in a pre-arrest interrogation, and that is when you deploy your most powerful legal asset. The line is, I would like to speak with my attorney before answering any questions. Say it calm. Say it once. Say it early. I would like to speak with my attorney before answering any questions. Here is why every word in that sentence creates tactical advantage. I would like to, not combative, not hostile, not a demand. It is a polite, professional invocation. Before answering any questions, that framing legally closes the door on everything that follows. Anything an officer extracts after you have invoked your right to counsel can be challenged in court. Watch the live exchange. Officer, you seem a little nervous. Mind if I take a quick look in the back seat? You, I would like to speak with my attorney before answering any questions. Officer, I am not arresting you. You don't have a right to a lawyer right now. You, I understand. I would like to speak with my attorney before answering any questions. You said it twice. It is on camera both times. Do not say it a third time. Do not argue with the officer's claim that you do not have this right. That claim is a pressure tactic, and police are legally allowed to lie to you during a traffic stop. Officers can lie about evidence they claim to have, witness statements, video footage, and whether cooperation will help your situation. The one thing they cannot fabricate is an official legal document. That is why your countermove never changes based on what they claim. You are not playing their information game. You are exercising a constitutional right. Here is what happens when you do not deploy this move. Officer, mind if I take a look in the back? Driver, I have nothing to hide, I guess. That, I guess, just became voluntary consent. Consent cures almost every search issue under Fourth Amendment law. Once consent is given, all 4 things a defense attorney could have attacked, probable cause, the automobile exception, scope of search, and challenge to any warrant, disappear in a single sentence. Tactical summary. Play the attorney card early, deliver it calm, repeat it once if needed, and do not engage with claims that the right does not apply. You have now shut down the question track and the consent track. But here is where experienced officers have one more move. When both of those paths are closed off, they shift to something different. They start extending the stop, stretching out the encounter, asking unrelated questions, running names, waiting for backup. They are manufacturing time, hoping to build probable cause from your behavior. Move number 5 starts a clock that works entirely in your favor, and it is backed by a Supreme Court ruling they cannot argue around. Legal move number 5, start the detention clock with 4 words. Under Rodriguez versus United States, the Supreme Court made a ruling that every driver in America needs tattooed in their memory. Once the basis for a traffic stop is complete, meaning the officer has written the citation or determined no violation occurred, the stop is over. The officer cannot extend that stop without independent reasonable suspicion of a separate crime. Every additional second they hold you after handing you that ticket, that is time you can use. The counter move is 4 words delivered as a calm, neutral question. Am I free to leave? Say it once after you receive your citation or after the stop has clearly reached its natural end. Am I free to leave? That question does something tactically decisive. It forces the officer to legally commit to one of only 2 answers. If they say yes, you are done. You thank them, start your engine, and you leave. If they say no, they have just declared a detention, and that detention must be justified by specific, articulable facts. Everything that happens after an unjustified detention is on shaky legal ground. Here is the live exchange. Officer hands you a citation. You take it. You say, "Thank you, officer. Am I free to leave?" Officer, "Just sit tight for a minute." You, "Officer, am I free to leave or am I being detained?" That second ask is critical. You are documenting on camera that the stop has been extended and you are asserting your rights. If they say you are being detained, you respond, "What is the legal basis for continued detention?" Not confrontational, calm and exact. That question on camera creates the record for every courtroom challenge that follows. Now, tactical variations by state matter here. In Colorado and Maryland, the smell of marijuana alone cannot justify extending your stop for a search. In Texas and Ohio, courts have generally upheld odor as sufficient probable cause. So know your state's standard before you need it. In Illinois and California, there are additional passenger rights that limit what officers can demand during extended detentions. In stop and identify states like Nevada and Indiana, you must provide identification when detained, but that obligation does not extend to answering questions about your activities or destination. The field reality is this: time is evidence. I've reviewed documented stops where drivers were held for 30, 40, even 60 minutes while officers waited for a K-9 unit to arrive. Under Rodriguez, every minute of that extended detention without independent justification is a Fourth Amendment violation. Your repeated calm question, "Am I free to leave?" starts the clock on camera and builds the legal record in real time. Stay calm, stay tactical, stay in control. Tactical summary: once the stop reaches its natural end, ask if you are free to leave. If they extend it, document the basis. Time is your ally. Here's the field rule that covers every encounter. Officers have a playbook. Your job is to know it better than they expect you to. Be polite, not talkative. Cooperation does not mean conversation. Your composure is your tactical advantage. Get emotional, and you hand them control of the encounter. Stay calm, stay precise, stay measured, and you maintain tactical position from the first second to the last. The 4 counter moves you lock in right now. Number 1, am I free to leave? Deploy this to force the officer to commit to your detention status. Number 2, I am invoking my right to remain silent. Say it out loud, say it once, then go quiet. Number 3, I would like to speak with my attorney before answering any questions. This terminates all questioning and it works before arrest. Number 4, I do not consent to searches. Clear, unambiguous, stated on camera. These are not magic phrases. They are legal tools backed by constitutional law and Supreme Court precedent. Right now, say all 4 out loud. Am I free to leave? I am invoking my right to remain silent. I would like to speak with my attorney before answering any questions. I do not consent to searches. Say them again. Am I free to leave? I am invoking my right to remain silent. I would like to speak with my attorney before answering any questions. I do not consent to searches. One more time. Am I free to leave? I am invoking my right to remain silent. I would like to speak with my attorney before answering any questions. I do not consent to searches. Screenshot this. Write these down. Keep them accessible before your next stop. This is tactical education only, not legal advice. Always consult with a qualified attorney in your state for your specific situation. If this training gave you tactical tools you did not have before, hit like right now. Subscribe to the channel and ring the bell so you never miss a field briefing. Share this with someone who needs it, because everyone deserves to know how these encounters actually work before they are in one. Tell me in the comments, Where in the world are you watching from? And what time is it there? I read every response. Now, you just locked in 5 counter moves for one specific type of pressure officers apply, but they have an entire playbook beyond what we covered here. The next video breaks down additional officer tactics and the exact counter moves you need before your next stop. It is right here on screen. Click it now while this training is fresh. You never know which situation you are facing next. Know the moves, own the encounter,